is yours.
Thank you. Good afternoon, everyone. My name is Gus Chin. I'm a municipal judge for the cities of Holiday and Cottonwood Heights in the state of Utah.
Good afternoon. My name is Britt Creemeyer. I'm originally from Las Vegas, Nevada. I'm a We the People alum, and I'm currently a practicing attorney in Boise, Idaho.
And I am Les Volpe. I'm an attorney in Denver, Colorado.
We invite you to introduce yourselves, please.
Good afternoon. We are Unit 5 from Amador Valley High School, representing the Golden State of California. My name is Ayush Singh, and I'd like to thank you for listening to our testimony today.
Hi, my name's Ethan Young.
Hello, my name is Rama Narayanan. Once again, we'd like to thank you for listening to our testimony. We'd also like to thank our coach, Ms. Clark, and our timer, Ms. Hull.
Lovely. We'll proceed with the question, and congratulations on making it into these finals challenge. It reads as follows. Richard Posner wrote that the American public worries more about invasions of privacy than about summary proceedings against suspected terrorists, curtailments of the freedom of speech of the law-abiding, or the right of the media to publish government secrets. Do you agree or disagree with this statement? Why or why not? To what extent, if any, is privacy in jeopardy today? What protection, if any, do people have from privacy violations by governments or businesses? You may begin.
From colonial times to the modern era, from the Industrial Revolution to the digital age, privacy, the right to be let alone from unwarranted government intrusion, has been a defining feature of American democracy. But today, privacy is in the midst of a crisis. Its reach often determined by a person's race or class.
While Judge Posner is correct that Americans worry more so about invasions of privacy than terrorism, we disagree with the larger point he makes in his 2006 book, Not a Suicide Pact, that Americans should sacrifice their privacy in the name of public safety. Posner wrote, "Privacy is the terrorist's best friend, and the government has a compelling need to defend national security." Posner seeks to have us give up our individual rights and liberty in the name of the common good and national security.
Looking to our history, we dispute this argument. In Justice Brandeis's dissent in Olmstead v. United States, 1928, in which the court upheld a warrantless wiretap, he called privacy the most comprehensive of rights and the right most valued by civilized men. This illustrates why Posner's larger implication is incorrect. Privacy is universally necessary. A democracy is reliant on individuals being protected in their beliefs, thoughts, and emotions. While Olmstead was overturned by Katz v. United States, 1967, which held that individuals had a reasonable expectation of privacy, Posner's reasoning is eerily reminiscent of its faulty premises. He seeks to loosen necessary limits on government.
Privacy today is in disproportionately more jeopardy for those in poverty. In a 2017 report for the Century Foundation, journalist Barton Gellman wrote, "Welfare recipients have to watch every step like they're in prison." Stemming from welfare's vast surveillance and verification apparatus, those in poverty are forced to choose between essential benefits and their privacy. This cornerstone right is thus increasingly becoming a luxury a select few can afford. In order to secure a true democracy, privacy's benefits must be realized for everyone. A free society cannot survive if the existence of one of our most fundamental rights depends on how much money a person makes.
Our modern police state similarly deprives people of color of their right to privacy. As Howard University law professor Andrew Taslitz wrote in the Journal of Criminal Law and Criminology in 2003, communities of color are policed with a far heavier hand than whiter ones. In fact, a 2018 study by the Bureau of Justice Statistics showed that the police are twice as likely to stop African Americans on the street than their white counterparts. This race-based distinction illustrates a clear issue: a targeted deprivation of racial minorities' privacy that harms our democracy. The stark disparity also illuminates why Posner is dangerously wrong. The government cannot be trusted with the unchecked surveillance under the guise of national security if it already strips the privacy of the most powerless.
Given these dangers, protections from privacy violations by the government are crucial. One such example is in the landmark case Carpenter v. United States, 2018. Here, the Supreme Court mandated that law enforcement obtain a warrant before accessing a person's historic cell phone location data. Carpenter restricted the government from encroaching into our private realm unless they had probable cause to do so.
Privacy protections from businesses are different in nature because companies are not restricted by the Bill of Rights. One important protection is the 2018 California Consumer Privacy Act, which protects an individual's right to know what data is being collected on them. The law also reinforces democratic values. It gives customers more power by maintaining that businesses have certain fiduciary responsibilities.
Privacy is more than a source of political debate. Not just the foundation of our democracy, it is the foundation of our dignity and must be protected for all. Thank you.
Thank you. Mention was made of the disproportionality in terms of privacy protections. What suggestions in terms of legislation or any constitutional protections can you offer to disrupt this disproportionality?
So one avenue is proposed legislation. In 1967, actually, in the UCLA Law Review, Professor Albert Speer proposed a Welfare Recipients Bill of Rights. Number 4 on this list was protection from unreasonable searches and seizures. Promulgating such an order and protecting such a right would be essential in better protecting people's privacy.
Another avenue would be through the judicial branch. For example, the case of Wren v. United States in 1996 was a unanimous United States Supreme Court decision that declared that any traffic offense committed by a driver was a legitimate legal basis for a stop. Thus, this court case made no mention of the Equal Protection Clause, and the majority opinion clearly held that that was not the issue at hand here. So if we could overturn this decision and find that the disproportionality of the privacy rights that minorities have could be somehow incorporated into our legal definition of privacy and into the way we treat these police interactions, then I think that that avenue would also be helpful.
Building off of Ayusha's...
Sorry, I'm going to have my colleague chime in with a question here.
I do have a question, because you mentioned here that we're in a police state and that minorities are not awarded the same types of protections that non-minorities are, and that African Americans are twice as likely to be stopped by police officers. How do we fix that? Do we do more implicit bias training? I mean, how do we fix such a huge problem? Because it's not going to come from the legislature or the judicial branch. What do we do to fix that?
In a 2013 article for the Cato Institute, Professor Michael McWarner actually identified the war on drugs as a cause of what is making Black America not succeed. And he explained that because government's prohibition on illegal substances jacked up the cost so much, it gave Black teenagers no viable alternative. And the allure was so strong to participate in this illegal trade that it often set them on a path of life that caused them to have frequent run-ins with the law and not successful in the traditional sense.
And picking up where Ethan left off, there's also a phenomenon of overcriminalization. In fact, Judge Alex Kaczynski of the Ninth Circuit once wrote an article called "You're Probably a Federal Criminal," pointing to the overabundance of laws in America, and alluding to what Ethan was pointing to, there are restrictions on non-violent drug offenses with mandatory minimums and sentences that are often too high. So criminal justice reform with legislation would be a good avenue for reducing this disparity in terms of the erosion of privacy.
Les,
Finally,
have a question, please?
Yes. You're talking about the invasions of privacy and its impact on various groups. Certainly, privacy is under attack. In the case of US v. Jones, the court held that you could not attach a tracking device to a car. However, in today's world, we walk down the street of any big city and you're facing facial recognition cameras. They keep track of you wherever you are and wherever you go. It probably will impact the number of arrests, particularly with regard to minorities. And the question becomes, what do we do about the fact that cities and states are now using facial recognition, which, if you hold up your fingers, can even read your fingerprints?
I think part of the solution lies in Justice Sotomayor's concurring opinion in United States v. Jones 2012. She stated that I would not assume that all information voluntarily disclosed to some member of the public is, for that reason alone, disentitled to Fourth Amendment protection. Therefore, I think that the problem lies in itself in the third-party doctrine, which was first established in Smith v. Maryland, 1979. And it held that if you give up information to a third party, then you lose your reasonable expectation of privacy to that information. I think that the problem comes with the third-party doctrine because we need to figure out a way to change its interpretation and its application to facial recognition software information and metadata.
And picking up on the idea of facial surveillance, as Ron was pointing to, we can actually see this with the novel coronavirus pandemic. China, for example, uses facial recognition software to monitor infected patients. So I absolutely agree with you. And in fact, pointing to our theme and testimony, facial recognition also has a disproportionate effect on racial minorities, often flagging them as more likely to commit crimes or more likely to be suspects. So facial recognition ought to be regulated more severely.
Let's go to our final question.
Quickly, if we have a moment, if we are concerned about terrorism and criminal conduct, shouldn't we be willing to give up privacy for the common good and for security?
I would agree with that point. However, research shows that these very strict anti-terrorism mechanisms are not even effective. In a 2013 interview with Jeffrey Stone, who's a University of Chicago law professor and a member of a White House panel on NSA surveillance, there was no evidence that the agency's bulk collection of telephony metadata thwarted terrorist attacks. And the conclusion of that same White House panel was that the program was not essential. May I finish my thought?
Go ahead and finish your statement, please.
It was not essential in preventing attacks.
Lovely. Let's applaud them. Very well done. Wonderful job. We will now provide you some commentary. I am very impressed by the level of responsiveness you provided to the variety of questions that were posed to you, particularly to your case law knowledge. Some of you were very adept in understanding the different positions that were taken, and very impressed by the application you had in terms of the ideas that you shared. I would hope that given your knowledge that you have garnered in preparation not only for this, but for your careers, that you will be participants, civically and otherwise, in ensuring that the ideals you seek are realized for our future, which we rely on you to protect.
I echo what Gus said, and you might have seen me mouth something. My husband's from California. He grew up in Pasadena and went to Bishop Almont. So I was telling him, I was like, listen, because he's been trying to stay away, but I wanted him to hear you guys so he could hear how well his home state does. Every year I come back and I report to him about the California teams. I am always so inspired when I'm like frantically wanting to ask you guys more and more questions because I'm excited to hear your opinions. You tackled a really tough issue. Anytime you're going to bring socioeconomic and race into a question like this, which is, I hadn't seen that today. We hadn't seen any other teams bring that up. That is a very difficult issue. It's a difficult topic to tackle and something that needs to be brought to light more. And I appreciate you reminding all of us that this is bigger than what we even recognize. A lot of us think about it in terms of, we're being tracked because of social media, but we sometimes don't think about how this type of tracking puts certain groups of people even at a bigger disadvantage than they already are at. I saw it on my day-to-day practice as a public defender, so I'm very familiar with how these can play out in the court system. I am so glad that you guys opted to Zoom in and do this. I know that it wasn't probably the most ideal. You guys did incredibly well. You had a great flow. You're passionate about this topic. You're well-versed, you're knowledgeable. And I know that whatever you decide to do, you will be quick to adapt. I look forward to having young people such as yourself in the workplace with me. I know that I will learn so many great things and continue to be inspired by you all daily.
Again, congratulations for your hard work under difficult circumstances. I'm sure that when you first signed up for this class, you didn't anticipate that you would be doing all of this by Zoom. I don't know whether your school has any classes going on at the present time or not, but congratulations also to your teacher for being able to organize you and to get you ready for this competition under quarantine circumstances. I thought you did a marvelous job in terms of understanding where we are with regard to the invasion of privacy. It clearly is under threat at the present time, not only, as you pointed out, from government entities, but also from businesses. And I thought it was very interesting that as one of the last points you brought up, you cited research indicating that simply accessing this information does not prevent terrorist attacks. And I think that is a very strong argument for limiting government's ability to search every aspect of our information, our personal activities, so forth and so on. And the whole idea of the fact that you cannot walk down the street these days without the government knowing exactly where you are and what you're doing. If you carry your cell phones around with you, somebody knows exactly where you are at any given time. This would have been totally unanticipated by our founders and by anyone prior to the modern era, that anyone could keep track of you in this way. And I was happy to have you respond to US v. Jones in the sense that the court said you can't attach a tracking device, but that's somewhat old hat at the present time. We are now keep track of everything. And as I told you, if you hold up your fingers, your fingerprints can be read. And therefore compared to crime activity and the like, which will probably have an impact on the minority races as you have discussed. Thank you for your hard work. Thank you to your teacher for her hard work. Good luck in the competition.